All right. We're back on the record in 2024 CR 4089 State versus James Brandyburg. Parties re-announced, please.
Raymond Saldana for the state.
Adrian Bettis for the defendant.
All right. Where we left off, defense had entered defense exhibits 1 and 2. Counsel, are you asking for this to be a part of the record or?
Yes, Your Honor.
All right, then defendants exhibits 1 and 2 is admitted without objection. Any other witnesses from either party?
No, Your Honor.
All right. State, you're opposed to the defendant's application and you're asking for 3 years in the prison?
We are, Judge.
All right, you may proceed, State.
Mainly, Your Honor, we have extended probation to the defendant in 2016 for this very charge, a violation of a sex offender registration. He was given probation for 4 years in 2017. Then in May of 2018, he picks up another violation of a sex offender registration, which is what triggers an MTR, and his probation gets revoked. He gets sentenced for 2 years in KDC. And then here we are again in 2024 with a new violation of a sex offender with a previous conviction offense. We just don't believe that probation is something that Mr. Brandyburg is going to successfully complete. We did take into consideration the mitigating circumstances, which defense will argue, which is why I offered a capital 3 in this case. So we asked the judge, the court sentenced him to 3 years and denies application for both deferred and community supervision.
All right, defense.
Judge, I'm asking that you place him on community supervision. It's very important to Mr. Brandyburg that he have structure. It's very important to him that he's able to prove to himself that he can complete probation. As the court knows from the defense exhibits that have been admitted, he does suffer from PTSD, anxiety, depression. He's had a lot of problems in his past. And because of those problems, he spent a good deal of his most recent life being homeless. And when you are homeless, it's difficult to comply with registration and with probation. But he tells me that he is in a position to do it. And he states, moreover, he was in compliance, but not putting any blame on the people that he was registering to, but he would be in compliance, but not on strict compliance. And the people that he was reporting to were letting a lot of tardiness slide. And he understands now that there is no accommodation for tardiness. If he's given another shot to do this, he needs to stay on top of his registration and on top of his probation. And I think that he can. We have discussed perhaps him going to Haven for Hope until he could get on his feet. He tells me that he's done that in the past before successfully, where he was able to afford his own apartment for a period of time. He's had a series of bad circumstances, but I don't believe him to be a bad person. I believe him committing this offense multiple times because of his homelessness and because of his lack of plan. And he has a plan now, and he's asking that you give him a shot on probation. If you don't, Judge, then I'd ask for the minimum. Thank you.
All right. Well, in reading defense exhibits 1 and 2, and also reading the stipulations, it says that he has a wife, and I'm making assumptions. And if my assumption is incorrect, please let me know. It appears that he lives with his wife. That's what's in the stipulation. He speaks to his wife and his wife asks him how he's doing. So if that's not the case, then be sure to let the court know.
No, ma'am, that was a 6-year relationship that I was in. And the reason I actually had the second violation was because that relationship ended. And my residence, who was actually with that individual after that relationship ended, actually ended my residency. And that's what led to me not being able to register.
All right. So, and then in the stipulations, he last reported in November, and they were giving him some leeway because he was homeless. All he had to do was show up and report again. And this offense is in January. So they gave him 2 months, even though he was required to report every 30 days.
I thought it was the annual reporting, and I actually went and turned myself in when I seen I had the warrant at 9th Street. I went and turned myself in, Your Honor.
Okay.
I wish I had a better explanation, Judge, other than he was homeless, doing the best that he can. And he did, in fact, also, Judge, I do think that it's important to remember that he did, in fact, eventually register. Yes, he registered late, but he was not trying to evade any registration requirements. And also, as he said, when he found out he had a warrant for this, he did turn himself in.
Right, and turned myself.
But I don't understand. No, stop amening what your attorney is saying. What I don't understand is, you're supposed to report whether you're homeless or not. I'm assuming you have money for a bus, or at least if you had to walk, you would have made it there by December. If you had to, your last report date was November 28th. You need to report in 30 days. If you would have started walking, you would have been there before January. So I don't understand why he's not reporting when he's been to prison. You're asking a hard ask. Your attorney is asking a hard ask for the court.
Okay, pause right here. This is huge. The prosecution is basically telling the judge we've tried probation before, it didn't work multiple times in sentencing. Repeat behavior is everything. The state isn't just punishing this one violation, they're arguing a pattern, and when judges hear same offense over and over, their patience usually runs out fast.
To give you probation when you've been on probation before for not registering. And then while you're on probation for not registering, you pick up another failure to register, which is why they revoked you. And now you're back again for not registering.
I wish I had a better explanation for you, Judge, but those are the facts, and we're asking for leniency.
So, if I can speak, Your Honor.
Sure. You want to raise your right hand?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
James Ray Brandenburg Jr.
Yes, what would you like to say?
I was depending on other people to get things done. And now it's just me that I have depended on.
How old are you?
I'm 41.
What other people are you depending on to make sure you're registered?
Well, that's the one I was in a relationship with for 6 years.
But is
It wasn't
she,
serious.
but here's the thing though. Is she the one who needs to register? No. So I still don't understand why you're not following through. You're in your 40s. You're not 18 or 19. If he were 18 or 19, I could understand. Oh, I'm dependent on my mom to drop me here or drop me there. But at some point, it's all on you. Anything else from either side?
No.
No, Your Honor.
All right. I just don't think probation is a good fit for you. And mainly because you were placed on probation previously for failure to register. And while you were on probation for that failure to register, there is a motion to revoke file. I think it was denied. Then you pick up another failure to register, and then you get revoked. And now you're back here as an adult man in your 40s saying you depend on other people to register you. And you reported to them November, and they told you you need to be back in December. And obviously they gave you some leeway because maybe you told them you were homeless or whatever. And then you still didn't report until January.
That's when they explained to me, if I do it annual, I have up to 30 days before and 30 days after. I didn't know that if I was doing it monthly, it wasn't the 30 days before, the 30 days after. It's actually 3 days.
No, here's the thing. When you go in to report, and people, please correct me if I'm wrong. When you go in to register, just say, I'm here to register. They give you the next date that you're supposed to come in and report. Am I wrong? Or did they say, good luck to you, we'll see you whenever we see you?
No, it's
They-
a blue slip.
They give you a piece of paper and say, this is the next day you're to report. So are you telling me that they didn't give you a blue slip telling you when the next time you were to report?
Yes, ma'am. But it's 30. I thought it was 30 days before, 30 days after, just like the annual registration is.
No. But here's the thing. They put a specific date on there for when you're to report. Am I wrong? Oh, am I wrong or no?
No, they
Okay.
didn't put a specific date.
So I don't think probation is good for you. And I'm telling you right now, I'm taking in consideration that he's homeless. I'm taking in consideration of what I've read in Defense Exhibits 1 and Defense Exhibit 2. So I'm going to find you guilty. I'm going to sentence you to 2 years in the prison, give you credit for any time served. And I saw that his violation that he has, there was some mention about him getting parole on that, or he thinks he's about to get parole on that. That was in one of the defense exhibits. So is there something that he has that he's getting paroled on?
No, that was for a previous, those records are a bit old.
They paroled me actually last time I went down.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am, I
And
did.
did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. You know you must register, right? When you are released from prison on parole, you need to head directly, whether they tell you or not, you need to go directly to where you're supposed to register.
Now this is the defense's core strategy context over crime, PTS, depression, homelessness. They're building a picture that this wasn't defiance, it was instability. Legalitis is mitigation. Emotionally it's a plea for compassion, but hey, raise the tension. How much hardship explains missing legal obligations, and how much sounds like an excuse. Judges wrestle with that line every single day.
Get a card from them asking them what's the next date you need to register. You understand? And this whole thing with somebody giving you leeway or being a little bit lax, you can't be a little bit lax. You know why? Because you're looking at prison, and you're going to get to a point. I don't know about your history, whether you're already at that point, but you can end up being filed on as a habitual. And then your minimum will be 25 years in the prison. So what you need to do while you're at the prison, and I recommend therapeutic community, because I know there's some mental health going on as well.
Thank you.
If there is an issue, you need to talk to them about it, and you need to come up with a plan. I saw in Defense Exhibits 1 and 2, where at some point in time, somebody had a plan for you, and you said, I'm not going to do that. I'm going to do something else. You need to get a plan from the prison. How are you going to get housing? How are you going to do all of these things? Because you have to register, there are many places that will not let you stay there. So you're going to have to really look around, or either you're going to have to end up leasing a house or renting a house or something, because usually apartment complexes will not let you stay. You understand? All right. Good luck to you. Okay. Counselor, if you give this to the court reporter, please.
Yes, thank you.
Thank you.
There you go. Thank you.
April Pettis. Hello. Good morning. How's it going?
Well, we're here on a bond reduction, motion to set bond.
Okay. All right. Court is calling 2024 CR 2756, State of Texas versus April Ann Pettis. Can I have parties announced for the record for the state?
Andrew.
And are you Miss Pettis?
Yes.
All right. Counsel, you've filed a motion to set bond. State, have you had a chance to review defense counsel's motion?
Yes, Your Honor.
All right. Is there a proposed agreement or no?
I believe so.
Yes, Judge, I've conferred with the state. I believe they've agreed to set it $5,000. Previous bond was $2,500.
All right. And why doesn't she have a bond?
She was previously out on bond, and she was under the belief that her case had been dismissed. It was indicted. She was not aware of the prior setting, and so she did not attend court, and as such, a bond forfeiture was issued.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Brian Pettis.
All right. At the Bexar County Jail, are you in general population? Are you on any type of medications?
No.
Have you ever had any mental health issues in the past? Have you ever been diagnosed with any mental health illness? Have you ever used any type of drugs in the past?
In the past?
Yes. All right. And what have you used in the past?
I used meth.
Okay. All right. This is what the court will do. The court will agree to your bond. The court will set the bond at $5,000, and the court is going to require 90 sober meetings in 90 days.
Did you say 90?
Yes. 90 sober meetings in 90 days. All right. We can go off the record. Where are we on discovery on this case?
Judge, I was just assigned to it last week.
Okay.
And so I need some time to go through discovery.
All right. So I'm going to give you a general reset.
I believe we've already been placed on the docket for 30 days, Judge. It was only,
I think so, because it's not listed on my, let me see. No, we only have this setting.
that's fine, Judge.
All right. So Norma, all right, we're going to recall this for November 21st. And that's just to see where we are on discovery.
Yes, Judge.
All right. And then let me give you a reset. And you need to make sure you're here on November 21st. If you're not here, a warrant will be issued. Do you understand?
Yes, ma'am.
Your Honor, did I hear that correctly? November 21st?
Yes.
Thank you, Your Honor.
You're welcome. You may be excused.
Thank you, Your Honor.
You are counsel. If you ever sign that and put an email address on that, if she has one, please.
I have one in my bag. Signed here.
Hold that for you. Hold it to-
There you go. What address? Email address?
Yeah. It's
Just put it over here.
right here.
All right, Judge, may we be excused?
Yes, you may be excused. All right, who's here on Thomas Henson? So before we go on the record, we did do a plea of true on the motion to revoke. Was the motion to revoke heard?
We just did a plea of true, Judge,
Okay.
and then we reset along with those plea.
All right. Court is calling 2024 CR 009236W, State of Texas versus Thomas Henson. Can I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense?
Attorney Albert Oswald for Mr. Henson.
Are you Mr. Henson?
Yes, ma'am.
You entered a plea of no contest on September 12th to the offense of evading arrest detention with a vehicle. According to the plea bargain agreement, the state is recommending community supervision. This is the run concurrent with 2022 CR 5859. State is taking in consideration 2024 PF 06107, 2024 PF 06357, and the state is silent on your application for deferred adjudication.
Phew, that tone shift. That's a judge who feels like she's heard this story before. Notice what she focuses on: personal responsibility, not paperwork, confusion, not other people. You in court. Once a judge starts breaking things down this plainly, you could have walked there. It usually means the window for probation is closing fast.
Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
None from the state, Your Honor.
No objections, Your Honor.
Any witnesses from the state?
Not from the state, Your Honor.
Defense, any witnesses?
Yes, Your Honor.
Yes, call your first witness.
I'd like to call Denise Torres. Yes.
All right, can you,
At the time, I was not in a very good mental state. I was in an abusive relationship. Things just got out of hand.
abusive relationship with who?
With the Stacey Reyes, ma'am.
All right, she said you tried to run her over in the police report, which you stipulated to this. Samantha Lopez?
Yeah. Good morning, Judge.
Good morning. All right, court is calling 2022 CR 4501, State of Texas versus Samantha Lee Lopez. Can I have parties announced for the record? For the state?
Ashley Jones.
Defense?
Amir Memorial.
And are you Miss Lopez?
Yes, ma'am.
Counsel, have you received all of the discovery?
I have, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lopez, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Ms. Lopez, did you review the admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, family, choking, strangulation? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
And there it is, prison time. But listen closely, the judge actually went lower than the state requested. The prosecution wanted 3 years, she gave 2. That tells us something important. She didn't ignore the mental health and homelessness, but she still believed community supervision had already failed. This is what sentencing often looks like, not maximum mercy, not maximum punishment, but something in between.
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at $1,500 fine. State recommends deferred adjudication. This is to run concurrent with County Court Cause number 633165, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be 160 hours of community service restitution, no contact with Stacy, Stacey, Reyes. There's to be the BIP course, TAP evaluation, and no possession of firearms. Legally, you're not allowed to possess any firearms. Do you understand?
Yes, ma'am.
Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea?
Yes, Your Honor. State would offer to admit State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, in state, have you had contact with the complainant?
Yes, Your Honor.
All right, you may be excused.
Thank you, Judge.
Ms. Lopez, did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court would defer finding of guilt as you applied for deferred adjudication. Is there anything you wish to say on behalf of your client?
We respectfully ask the court to follow the agreement, Judge.
All right, why are you violent? What's going on with you?
At the time, I was not in a very good mental state. I was in an abusive relationship. Things just got out of hand.
Abusive relationship with who?
With the Stacy Reyes, ma'am.
All right, she said you tried to run her over in the police report, which you stipulated to this. She says that you ran her over with a car before. And according to this, she went out, she got promoted at work, she didn't come home, she decided to celebrate with whomever she decided to celebrate with, and then she's saying you choked her and beat her up. So again, what's wrong with you?
Ma'am, at the time, we have been together for 15 years before that, off and on relationship. We had a lot of issues.
So why don't you just leave? According to this, after you ran her over with the vehicle, why didn't you leave? I'm thinking if you're in a relationship with somebody and it gets to the point where you're running them over with a vehicle, maybe that relationship should be over.
Yes, ma'am, I agree.
So why didn't you just leave?
I just wasn't in the strong enough headspace to leave. I felt like she was all that I had, and I wasn't in contact with family at all. So I stayed and things just got worse.
All right, but according to this, you're the one who's beating her up, not the other way around.
I'm the only one that got the cops called on me.
Well, when she said you ran her over with the vehicle, she said she was dishonest with the police and said, I don't remember what happened.
But I'm just saying, I never called the police on her. I could have several times, but I chose not to. So there is no record of that, unfortunately.
So for this, when this happened, They don't mention that you have any scratches on you. It's just she's the one who got beat up and choked out. So,
Yes, ma'am. And
so
that
obviously
night,
you can choke her out because you did.
yes, ma'am. That night, she did also put her hands on me, but I'm stronger than she is. I wasn't harmed as badly as I harmed her.
No, it says here there was an argument. She says you punched her several times in the face and choked her. And you choked her. They observed petechiae in her left eye from you choking her out, and that she pretended like she was just going to go outside to get some air, and you gave her her phone because you didn't think it could work, and her phone was broken.
Yes, ma'am.
So it appears you have an anger issue. So
Yes,
where
ma'am.
is your anger issue coming from, and why do you think that might makes right in relationship? Because that's what's happening here.
The anger was just stemming from all the past history of that relationship.
This is a totally different kind of courtroom moment. Bond isn't about guilt, it's about risk and accountability. The court is basically saying you can be free, but you're going to prove you're stable in 90 sober meetings in 90 days. That's intense. That structure. Courts use conditions like this to test whether someone can follow rules before trial even happens.
I have worked on myself a lot since then. I'm not denying anything from that night. I know that I did wrong, and I have regretted it since then. Since that night, I never put my hands on her after that because I felt so badly about what I had done.
Are you all still together?
No, ma'am.
All right, because that relationship is over. You understand that?
Yes, ma'am.
Do y'all have any children together?
No, ma'am.
Do you have any property in your name
Together?
with her? Yes.
No, ma'am.
All right, so that relationship is over.
Yes.
Do you have any children?
No.
Are you employed?
Yes, ma'am.
What do you do?
I work at a nonprofit pet rescue.
Mhm.
I'm a supervisor.
All right. So this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine that will be probated. This will run concurrent with 633165. That's a misdemeanor case. There's to be an affirmative finding of family violence. There's to be no contact with Stacy Reyes. And if you're doing sober support meetings with that DWI, I know sometimes they tell you as part of your rehabilitation, you have to apologize to people that you've done wrong. You're not allowed to apologize to her. You understand?
Yes, ma'am.
No contact. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Make sure they test for alcohol. Field visits 1 time per month for 3 months. The BIPP course. TAP evaluation out of custody. And probation, since she's on probation in the misdemeanor case for a DWI, they may have already done a TAP. If they have not.
No, Your Honor, that plea hasn't been.
Oh, it hasn't been done?
No, Your
Okay.
Honor.
So TAP evaluation out of custody. I'm going to want 90 sober meetings in 90 days. There's a 160 hours of community service restitution. Probation, I know what BIP does, but is there any type, she's saying that she was abused as well. Is there any type of program for her? All right, we'll do trauma assessment. And if trauma assessment requires a class, then I'll waive the 160 hours of community service restitution. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Relationships are work. People think it's all bed of roses. It is not. Anybody who's been married for a long time, they will tell you it's work. You know, relationships and marriages are not the wedding. It's what comes after. So this is what you need to do. You need to go to one of these stores, get you an orchid. They are beautiful. They have beautiful flowers on it. Make sure you get one that has all the flowers on it and bring it home. And when those flowers fall off, if you're able to get that orchid to rebloom, then maybe you're ready for a relationship. And let me just tell you why I say that. Orchids takes patience. They take time. You get those instructions from the store and then people tell you, you're not supposed to put ice in orchids, right? But they give you instructions to do that. Orchids don't like to be moved around. Sometimes they're very finicky. They like the sunlight, then they don't like the sunlight. And if you are patient enough to get that orchid to rebloom, then maybe you'll be ready for a relationship. Because guess what? A relationship requires patience. It requires acceptance. And anytime you're thinking about throwing that orchid away, that's like with relationships. Anytime you think about putting your hands on somebody, maybe it's time for you to leave. You understand?
Yeah.
All right. In this court, communication is key. If there's an issue, you need to let your probation officer know. If you feel as though they're not addressing your issue, you can come to court. And if the complainant comes back to you because maybe she wants to rekindle things, you need to call the police, because otherwise you're going to be violation of your probation if you visit her and if you allow her to live with you. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
You're welcome.
Maybe excuse Judge.
Yes. Thank you, counsel. All right. Brandy Burr.
I did not expect life advice via houseplant, but here we are, and honestly this is one of those rare moments where a judge steps out of pure legal mode and into human mode. She's saying relationships take patience, not control, growth, not force. It's symbolic, but it's also a warning, because if that violence happens again next time, the speech might be replaced with a prison sentence. What do you think? Heartfelt guidance or crossing the line into a lecture?